Start. Reference may also be had to the judgment of the Honorable Supreme Court in the case of Sukhbir Singh and others versus Brijpal Singh and others AIR 1996 SC 2510, where in paragraph 5 the deposit sale consideration in the court would have the effect of placing the parties on equal footing. There was no proposition laid down, as argued by the learned counsel for the defendant, that no interim order can be passed against the defendant in a suit for specific performance of agreement for sale of immovable property unless the entire balance sale consideration is deposited in court. As far as the case of SABH Infrastructures Limited versus Jayashree Supra is concerned, that was a case where the plaintiff had paid a sum of rupees 21 lakhs when he entered into the agreement, whereas the learned single judge had directed him to deposit a balance consideration of rupees 1.74 crores. The court noted that the plaintiff has invested only a sum of rupees 21 lakhs in a property transaction, the total value of which was rupees 7.40 crore. The matter pertained to a collaboration agreement. It was in those circumstances that the division bench took the view that there were no grounds to interfere in the order passed by the learned single judge exercising discretion and directing the plaintiff to deposit the said sum of rupees 1.74 crores. In that case, the defendant had strongly urged that the suit is not maintainable inasmuch as a collaboration agreement or MOU is not enforceable. It was on those facts that the learned single judge had passed an order for injunction based on deposit of the amount of rupees 1.74 crores. The court had in the said judgment noted as follows: the observed has not been considered, namely whether it is equitable that on payment of a meager sum which represents less than 5% of the consideration, a plaintiff would be entitled to freeze transactions on a property for a substantial period of time, where property prices are volatile and incident. It would always be the interest and endeavor of a speculator to file a suit for specific performance by creating the illusion of disputes. The other argument of learned counsel for the defendant, namely that the plaintiff has not come to court with clean hands, would also not have a bearing for the purposes of determination of the present application. Defendant has prima facie not been able to show any serious prejudice due to the stated acts which allegedly constitute acts of the plaintiff in not approaching the court with clean hands